where we are going to record a discussion with the co-chairs of the task force that was responsible for helping us revise and enhance CPR's employment-related mass claims protocol. And I'm joined today in doing so by Aaron Warshaw, a partner at Ogletree, and Jahan Sagafi, a partner at Outten and Golden. And for purposes of the tape, my name is Alan Waxman, and I am the president at CPR. And so I'm delighted to be joined by both of you. Let me just first say that the protocol was designed to really help facilitate resolution by providing for a detailed path that would help both parties in these very complicated, I should say all of the parties, in these very complicated mass claims matters, find a way to resolving these. And so let's dig into what that detailed path looks like. And let me begin by asking each of Aaron and Jahan to first introduce themselves and how they came to be involved in mass claims matters. Jahan, let me start with you.
Right, great. Thank you, Alan. And thanks everybody for including me in this process. I am a workers' rights advocate at Outten and Golden, and I prosecute claims on behalf of workers in areas of discrimination, wage theft, and all sorts of other areas in class actions and mass actions. So when Alan reached out at the beginning of this process, I was really impressed with how much he wanted to ensure that there was a balanced set of perspectives and a diverse pool of people on the task force to really reach the best possible solutions for the mass claims protocol. So thank you for including me. It was great to participate in it, and I'm happy to be here.
Well, great. Thanks, Jahan. And Aaron?
Hi, everyone. Nice to see everybody attending. I wear two hats. By day, I'm a shareholder at Ogletree Deacons in the New York office, coming up on 10 years at the firm, and handle everything management side and employment cases, including not least and at all wage and hour, and that would include class actions and collective actions. And certainly since the Supreme Court, at least for now, and unless Congress decides otherwise, held that waivers of mass claims, as we would typically see in a wage and hour case, are enforceable, there's been a problem, and frankly, it's a problem for both the employment and the employee side, of mass individual claims. So rather than adjudicating a large collective or class action in court or even in arbitration, we have been seeing, certainly in this area, as many of you on here know, a series of anywhere from 25 to 50,000 individual wage and hour claims being litigated. So certainly when CPR first rolled out the 1.0 version of the mass claims protocol, I was happy to work with Alan and provide some feedback. And I said I wear two hats. My other hat is as currently the sole chair of the Employment Disputes Committee, hopefully soon co-chair, and was just really thrilled and happy to get involved. And just to echo what Jahan said, to put in a little plug, this committee just worked tirelessly and with a lot of collegiality, which we don't often see in our world. We're often at loggerheads and it's personal and acrimonious. And it's just been kind of a testament to what CPR is all about, that, I now consider Jahan a friend and a colleague. We will never be on the same side of a V, I suspect, in our career. But, when you take off your litigator hat and kind of look at things from an objective perspective, there's just a tremendous amount of common ground.
Yeah, if I could just echo that, it was intellectually very interesting, and there was a really great sense of respect and collegiality in the whole process. So that was really nice, even when we were disagreeing, somewhat strenuously about things, but it worked out really, really well. So thank you, Alan, for overseeing that.
Well, wonderful. So let's get to some of the fruits of that labor, and thank you all for bringing your ingenuity and your hard work to this. First, let's just start with Aaron mentioned wage and hour claims. Jahan, you represent claimants. What types of claims are we likely to see coming in as mass claims? Is it simply wage and hour? Will we see other types of claims in the mass claims area?
Yeah, I mean, I really think it can be anything. My own personal experience with CPR and other providers has been in wage and hour claims, but there's no reason that it wouldn't encompass discrimination claims, FICRA claims, all kinds, really anything that could have been a class action yesterday, maybe a max action tomorrow. And obviously, as Aaron hinted, the landscape is always changing, and so Congress and the Supreme Court have an ongoing conversation for the past 100 years that will put some things in and out of arbitration, but it really could be anything.
So, Aaron, what makes having a bunch of these kinds of claims, be it wage and hour or other types of claims, what makes that so challenging? And just briefly outline, what is the procedure that was laid out in the protocol designed to address those challenges?
Yeah, I mean, as Jahan said, you can see this issue really in any type of employment dispute, just by virtue of the volume of wage and hour cases that are filed. It is a typical issue, and it's the problem. A mutual problem is what prior to the Supreme Court upholding waiver of mass actions would typically be adjudicated as a collective or class action. If an employer has chosen to include a waiver of those types of claims, meaning collective class coming together of a group, then rather than having a mass arbitration, you've got a mass of individual arbitrations. And so, there's pluses and minuses to that. One of the clear minuses from a management side is, and we've seen it, and it's hit the press. So, imagine you're an employer. Instead of having a 50,000 member collective or class action, you've now got 50,000 individual claims filed with an arbitration provider, each one with their own arbitration fees of, let's say, $10,000 to $25,000. I went to law school, not business school, but I can multiply 50,000 by 1,000, and I get a number with a ton of zeros. And so, some companies say, fine, we'll pay it. We'll see you and, try to litigate 50,000 of these. Some will say, why are we paying $50 million for, something that exposure isn't that great? So it's a problem. And, consistent with CPR's mission to resolve problems and resolve disputes, the initial protocol 1.0 set up a system that our committee really took a look at. And, we kind of had two phases. The initial phase was just kind of more of the ministerial changes and cleanup work. And so we kind of came up with version 1.1. And then we took a deeper look and seeing if there was any structural changes we could make. And that's the version 2.0, I'm sorry, that I just sent the link on. And before I forget, and I really don't want to forget, I just want to give a shout out to all of the committee members who just really, gave up time for all our meetings, and were just very sensitive and thoughtful. So just really quickly, if you open the link either now or at some point, you'll be taken to the dispute protocol. And I'd suggest you take a look at the second substantive pages of the protocol, which are essentially the executive summary. This is intended to be more employee facing. So, all of the real rules that we worked hard on kind of comes after that, but this is a good summary. And essentially, when 30 or more similar claims against an employer are filed with CPR, the protocol uses the decisions from test cases, and there's a process to determine what a test case is, to come up with outcomes. And then there's a process by which the outcome of those test cases can be used to facilitate a collective resolution of all of the claims. you know, read the rules, because I don't want to, you know, I could spend 2 hours talking about what all of that means, but that's a real real high level summary. And so, you know, look, I mean, there's an example of this in the world of class action in court, where whether it's multi-district litigations or things like that, you will take a series of cases, get enough fact patterns, get enough outcomes, that then you can have the parties sit down and say, well, you know, we thought we were here and here, maybe we're only here, and so in mediation we can close the gap and resolve it. You know, in my view, that's the intent of the rules.
Well, thank you.
I thought one thing, and I'll kick this over to Jahan, because I know it's one thing we want to talk about. One of the other unique features is there's an administrative arbitrator who has some oversight. Jahan, do you just want to briefly touch on that?
Sure. Yeah, I think this is a nice feature because we obviously have individual assignments of cases to individual arbitrators, but this is in the context of a mass process that is designed to get the parties to a global resolution if possible. And so the isolation of individual processes could lead to kind of a wandering in different directions. And so to the extent that there are overlapping issues, you might need to substitute test cases if individual cases settle or something happens to one of those cases. You might have your 10 cases dwindle to 7 to 5 or who knows what. And do you want to substitute new cases? There may be issues with discovery that can be conducted in individual arbitrations, but is there a way to reach some efficiency or to leverage discovery in one case and another case? You know, other kinds of procedural questions that the administrative arbitrator kind of has an umbrella view over the process for, and she is available to the parties. And I think that's a really great feature that's built into this.
Well, great. Let's walk through at a little bit more granular level some of the aspects of the protocol. So Aaron mentioned the identification of test cases. Jahan, what happens to the remaining cases, the cases that aren't identified as test cases when the protocol begins?
So those cases will be held aside. And so we focus our efforts on this initial corpus of test cases. And from personal experience and from thinking through the protocol, I can tell you that, you know, that keeps you plenty busy to be working on 10 or 7 cases at a time with different arbitrators on different schedules and different issues popping up. So, you know, your next 100 or 10,000 or however many it is are held in abeyance and don't need to be assigned to arbitrators and so forth. And then you move forward with those test cases, as Aaron said, to kind of give the parties insight into how strong these claims are, hopefully in a fairly representative capacity. So they're effectively acting as bellwethers as they would in a mass tort in an MDL, for example.
And so what happens when the test cases are completed? What happens to the outcomes of those test cases? So
then for those following along at home, we're at around paragraph 7 now of the protocol. And so the arbitrator issues an award. The award is then anonymized in preparation for presenting it to the mediator. And so then we begin the mediation process. So we've gotten our 10 results or thereabouts from our bellwether test cases. And the respondent pays the mediation administration fee. The parties agree on a mediator from among CPR's panel. If they can't agree, CPR nominates 3 and the parties agree or rank. The respondent pays the mediation fee, the mediator fee, and then CPR provides those anonymized awards to the mediator. And so now the mediator has, in addition to whatever mediation briefing the parties want to submit, has this body of law, of precedent, as it were, to contemplate in guiding the parties to a resolution. So, the object of that process then is that the parties come together, realize their risk in both directions, and try to reach what's called a substantive methodology for resolving the arbitrations, both the initial group and any newly commenced arbitrations that kind of come along. And so then that methodology is supposed to include the terms and objective criteria that you would need effectively as a settlement agreement. And so that could be substantive components like a formula, a plan of allocation, a formula for calculating people's awards, and procedural components. What's the threshold percent of participation that the claimants council needs to go and get from their 1,000 or 10,000 clients, because they're not going to get everybody. And what's the timing? What's the mechanism for notifying the clients? All those kinds of procedural aspects. So basically, the end result is a mass action settlement agreement that has been mediated through the oversight of the mediator.
So you go through this mediation process, everybody comes together benefited by these decisions, it sounds like, and you're really attempting to put this framework together. Aaron, let me ask you, under the protocol, what makes for it being a successful mediation process, and what's the consequences of a successful mediation process?
Yeah, and just briefly, I think I sent the wrong link, so thank you to whoever corrected my mistake. And if you are following along, we're up to paragraphs 14 through 17. So essentially, as part of this process, each claimant is then offered the settlement that presumably has been negotiated between counsel, and counsel for the claimants has at least opined or taken some position as to the fairness or whether it's good resolution. Because these are still individual claims and need to be adjudicated as individual claims, each individual still has the opportunity to agree to the settlement, take the advice of counsel that this is, a fair and reasonable outcome, or, just as in any mass individual claim or anything, retains the ability to reject the proposal and proceed on into arbitration.
What happens? So that's what happens if a global framework is reached. Jahan, what happens if a global framework is not reached? That is, after the mediation process, the parties through their counsel are not able to come up with a structure for resolving the remaining claims. What are the consequences then?
That's right. So that now we're at a fork in the road. And I guess it's not only if they weren't able to agree, but maybe they did agree and then the agreement fell apart because there wasn't adequate opt-in by all the individual claimants. So yeah, for whatever reason, we don't have a settlement agreement. And so at this point, any party can opt out of arbitration and go to court. And so the claimants have 60 days from the end of the mediation period or the commencement of arbitration, whichever is later, and each individual claimant can choose. And then that choice is communicated through counsel or directly by the individual. It can be communicated in bulk for efficiency's sake. And then the respondents collectively have to unanimously decide. The parties also have the freedom to switch that order if they know that the respondent is going to opt out and go to court. There's no point in asking 1,000 people 1,000 questions, so they may decide to do that. So as with many components of the protocol, there's inherent flexibility built in for the parties to agree to other approaches or seek guidance from the administrative arbitrator or CPR generally on other ways of doing it. But we, and again, that's sort of the theme for this entire protocol is we tried to build in robust structures and detailed processes to guide CPR itself and the parties in implementation, but also acknowledge that different cases are going to have different situations. And so if the parties want to agree to something else, for the most part, they can always do so. So yeah, that's the process.
Yeah, so and you've had experience representing a lot of workers and claimants. In your experience, why might a claimant want to opt out?
Well, I mean, a lot of times you have folks who feel like they are going to get a better shake from a judge in the public civil justice system. And I think harking back to what Aaron was mentioning at the very, very beginning about this conversation between Congress and the Supreme Court and the question of what is arbitrable and what is not. I think that's something that we all can be paying attention to, and I think it's great that there are so many neutrals on this call, and that we have, again, I'm really impressed by what a diverse group of people reflecting all sorts of backgrounds and professional experiences that CPR has. And I think that that's something important to pause on, because the credibility of the private civil justice system is really a critical question for our society. And we have Congress saying just a few weeks ago, sexual harassment claims, cannot be forced into arbitration. Well, why is that? Is there this, there's certainly a perception and there's a concern among social justice advocates like myself about the adequacy of the private forum compared to a public forum. And so knowing that those are questions that are swirling in the public discussion, I think it's really important for neutrals to just bear in mind that we have to prove the adequacy of this system and let the claimants experience that fair alternative to the public system. And so we don't want the narrative to be, as we've seen from some studies, claimants have a lower chance of winning in private arbitration than they do in state or federal court, or they get lower awards, or if they have an arbitrator who's worked with a particular respondent before, they have a lower chance of winning. So, we don't want that to be the narrative, and this protocol is sort of trying to build protections against that. So, hopefully those claimants will say it's just as efficient for me to go through arbitration, but a lot of times they do prefer court.
And if they go to court, and that is, if they choose to opt out and go in a different direction, might they then proceed with a collective action in court at that point? Does the protocol have anything to say on this? What are the consequences there?
Yeah, we spent a lot of time on this, and we concluded that it would make the most sense for the protocol to be silent on this. And so, that's really going to be a question for the court to decide based on the particulars of that case.
Wow.
Thank you, Jahan. So let me turn to you, Aaron. Just as I said to Jahan, he has a lot of experience representing workers and claimants. You have a lot of experience representing companies and management. And the protocol's optionality, if that mediation process is unsuccessful, is not only for claimants to be able to opt out, but for a company, a respondent to be able to opt out of the process. Why would a company want to opt out of the process at the end of an unsuccessful mediation period?
It's a really interesting question, and I think as we were working on this, this probably from my side of the aisle caused the most consternation. But it's interesting now that we've had the Supreme Court, or we've had Congress, weighing in, potentially taking this decision out of the hands of companies. I would frankly put as the number one reason that this option to go back in court, almost this hybrid approach in some ways, is a potential middle path from the kind of binary discussions that we see in Congress and the Supreme Court of it's an either or. You're either in arbitration or you're in court, and I think that's led to a lot of overstatements of both the benefits and the drawbacks of arbitration, which is kind of interesting. If you read the congressional record around the recent legislation, you would think that arbitration, you might as well throw your complaint in the garbage can and you'll never get justice. And then sometimes from the management side, you'll hear the other extreme of, the courts, are inefficient and all the rest. So, I would put as a number one point, which I don't even know that we discussed it at the time, that this is a way to potentially say to lawmakers, look, there is an alternate route that takes this creative, thoughtful approach. Some of the other things that we've talked about, and I think, would be of consideration to management. There's a control process on the front end to try to deal with this runaway fees issue, which is frankly driving a lot of these cases at this point. For a company that cares more about resolving cases efficiently as opposed to bludgeoning their current and former employees into dust. It's a sensible outcome. I mean, it is no great secret that 99 point whatever % of employment cases resolve. So why not do it quicker, upfront, more efficiently, rather than have both parties through protracted litigation? The parties will know, and the management will know a lot more about the case after you go through these test cases. I mean, again, if we're primarily talking about wage and hour cases and that there's common sets of facts and issues, it may not be necessary to litigate 10,000 cases. You may kind of know where your exposure is after 10 and getting a neutral to weigh in. And I think this is something that would be presented from an employee relations standpoint to employees. You've heard arbitration's evil and awful and, terrible, but look at this creative approach. The introduction is drafted, I think, very neutral with an employee focus. And ultimately, this is about resolution, not taking some rights away.
And if I could add one other thought, I mean, in terms of why an employer might want to opt out and go to court, I've certainly had scenarios where the company says, we're so confident on the merits, like we just want to put an end to this. And we want to get a good ruling that's public that we can then, sort of hold out to prevent people from continuing to sue us on these issues. So I think to the extent that the company is confident on the merits, there's an advantage to going to court for that reason.
Well, listen, this has been a great discussion. Thank you for the insights that both of you have offered, for the hard work you did in leading this group. And I too want to thank the entire task force, which was made up of fellow members of the bar from plaintiffs' counsel, workers' counsel, fellow members of the bar as defense counsel, in-house practitioners, as well as neutrals. And all of them really brought perspectives to allowing us to put this process together. And hopefully it does offer a more enlightened approach that will facilitate resolution. So thank you to both of you. Thank you to our constituents. And we will see and report back on experiences with the protocol as it moves forward.
Thank you.
Okay, thank you to both of Aaron and Jahan. And at this